Hello, everyone. Thanks for joining us today. Just our quick disclaimer, as we always do, this presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship with anyone who's not currently a client. Also, we're providing a quick overview today. We're talking about new laws for 2026. There are a lot of them. We're going to hit some highlights, but there's no possible way within the constraints of time that we have that we could hit every new employment law for every state. So we are just highlighting some of the important laws today that we see for the various states that we'll go through. If you're already a client, as noted, and you've got questions on the materials today, you can reach out to us with a question through our portal. And if you're not a client, but you'd like to become one and get some information on what we're discussing today, we'll have some data at the end on how you can sign up with us and become a client. And so you can move on with your day. We're going to keep this information moving along today and go through it, as I said, just as a highlight. We're going to start off with Alabama. We'll go through the stuff alphabetically today, so we're going to go through the states in alphabetical order just to keep it organized, but we're going to start off with Alabama. So what's going on in Alabama? Well, they have a new law called the Portable Benefits Act. And what this law does is it establishes a framework for independent contractors to create a portable benefits account that can be funded by both the independent contractor and by the hiring entity of the independent contractor. So this basically provides more flexibility for independent contractors to have some sort of retirement account set up that they can take with them from place to place. It really does benefit keeping people working and keeping them valued with a financial position where they can also have a convenient form of plan that they can move and take with them. This law also allows the hiring party, so in other words, the company that brings the independent contractor in, it allows them to contribute funds into the account without being considered an employer. So importantly, it provides legal protection to a company that uses independent contractors. They can put some money into this account and they're not going to be on the hook for being considered an employer. Basically, if you're going to be using this with independent contractors in Alabama, just be aware that this law exists. It's a way to provide a benefit beyond just pay to independent contractors, and that's a way as an employer or a hiring entity, I should say, to incent independent contractors to come and work in your organization because they can get additional benefit from you under this plan in addition to just their straight pay. So that's going to be useful in retaining and attracting independent contractors if you use those types of workers. Moving on now to California. As anyone listening knows who works in California, it's an extremely employee-friendly state, arguably one of the, if not the most employee-friendly state in the country, as their legislature seemingly never stops in passing laws that benefit employees and burden employers. Well, we're going to talk a little bit about that. With a few of these different laws that have gone on in California. Again, we're not going to cover every single employment law in every state, highlight some of them. So we're going to go through a few for California right now. And the first one we want to talk about is AB 406. And what that is it's an expansion of paid sick leave and crime victims leave. So effective October 1st, so a few months back, paid sick leave would cover jury service and court appearances as a witness. So in addition to the existing uses for paid sick leave in California, an employee could now use paid sick leave time for jury service or witness appearance in court. And then effective as of the 1st of this month, paid and unpaid leave rights are extending to victims and family members attending judicial proceedings for serious crimes. So employees can now use accrued paid sick leave when they're appearing in court as a witness to comply with a subpoena or court order, and they're serving on an inquest or in a jury trial. What I want to give you as a compliance tip with this change in law is be aware of this. Be aware that an employee could use their paid sick leave for some of these expanded reasons. Also, there's a posting requirement for employers. There is a poster that is available from the Labor Commissioner's Office. If you check the Division of Labor Standards Enforcement DLSE site, there should be a poster there, and that must be posted at a work site. Continuing with California, let's look at AB 692. That's the end of most so-called stay or pay employee agreements. That's an agreement where an employee must pay back or pay an employer for certain costs. It's been used in the past by employers to recover some funds invested into an employee. So an example might be a tuition reimbursement agreement, certain types of bonus agreements when people are hired. So any agreement going forward that an employee signs, in most cases, will not be enforceable if it has an employee requirement written into it to pay certain costs back to their employer. That is going to be a big issue if people are used to providing, say, a hiring bonus to an employee with a statement with the hiring bonus. If you leave within 6 months, you got to pay this back to us. That's the sort of thing that this law is looking to change. There are, however, some exceptions to this rule. There are some cases, in other words, where an employer could recover some funds expended on an employee's behalf, but those exceptions are limited. And with those exceptions, there are conditions under each of them. I'm just going to kind of give you the broad exceptions where this type of agreement might still be usable. The cases would include something like some sort of transferable credential certification, certain types of discretionary bonuses, if there are apprenticeship costs through an approved apprenticeship program, if the employee on their own will has bought something from the employer, if the employer has sold some sort of property to the employee, those types of agreements might still be enforceable. But again, this is something to really look at. If you're used to using these types of provisions, just be aware that sometimes they can still be used, but in a lot of cases they cannot. And if you are still using them, you want to make sure that you're checking in with us ahead of time or your other employment counsel to see if what you want to do is still legal in California. Okay, this next one is kind of a big deal, as they like to say. California Senate Bill 294, the Workplace Know Your Rights Act. This law became effective as of the 1st of this month. We noted this in our newsletter last week. We try to give you alerts on some of the bigger, more significant employment law changes that are happening throughout the year, but this one we specifically talked about. This rule, or this new law, requires employers to provide notices of labor rights to new employees and current employees annually going forward. And it also requires an employer to notify an employee's designated emergency contact in the event an employee is arrested or detained at work. So the annual notices for this for current employees, there's a due date coming up of February 1st, which is about 10 days out, where an employer has to provide this information to its current employees. It has to be a standalone written document. It's got to address employee rights regarding workers' compensation, union organizing, immigration protections, and law enforcement actions that might occur at work. The good news with this is that the California Department of Industrial Relations has a template available. You can go to their site and find the template. It's 5 pages long, just as a heads up, but that's a way that you can more quickly comply with this notice requirement. Also, under this law, as we just mentioned, it gives employees the right to designate an emergency contact in the event that they're detained at work. This law clearly relates to ongoing immigration enforcement actions across the country that are affecting employment. California, of course, has taken a very aggressive pro-employee stance by putting this law in place. So some compliance tips for employers with employees in California to think about are, get that notice to your employees by February 1st. Again, the official notice template is available from the DIR. You want to update your onboarding and annual notice processes overall. If you use a human resources information system, you may want to add a new emergency contact or notification field if you don't already do that. And then you want to maintain documentation of the notices provided and those emergency contact designations. Keeping on with California, this is another important law that affects many employers out there, SB 513. This is a law that broadens the definition of personnel records. Before this law was passed, personnel records were limited to things that relate to like performance, grievances, things like that. With this law, it's now legally expanded in California statutes what documents actually are considered personnel records, and that now includes education and or training records if an employer maintains those types of records. If you do have training or education records on employees, they are now part of a personnel file, and those records have some specific information they have to include. Has to have the employee's name, the name of the training provider or education provider, the date and duration of the training, the core competencies addressed in the training, and then the resulting certification or qualification from the training. We've been discussing this with some of our bigger clients out in California, and some compliance tips to think about are if you previously had training records that were sort of kept informally or separately, they're now going to be considered part of the personnel file under law in California. So that means they're subject to the retention and inspection rights as personnel records. If you've got those types of records, they're now part of a personnel file. You want to make sure that they're complete, they're properly filed, and they're made available upon request. If you don't do that and you're keeping those types of records, but you haven't included them in the personnel file with the proper information we just discussed, there's a risk of penalties and other actions by the state or the employee. So that's something you want to consider. The next state we want to take a look at is Colorado. This state has also become probably much more than people expected an employee-friendly state in the last several years. They have a family and medical leave insurance program out there, family. So paid family and medical leave is those programs exist in many states, and other states are adapting them and adopting them, as you'll see. They're expanding them. There's all kinds of things going on with paid family and medical leave at the state level. So this is one example. We'll go through a few today, but Colorado has updated their family law now to cover an additional 12 weeks for individuals taking care of an infant in the neonatal intensive care unit, or NICU. So this type of leave, the one thing to remember is that this is in addition to and different from the leave to care for a new child. So that enables an employee potentially to take up to 12 extra weeks of time off if they've got a NICU component to the time off, and then they have just the regular care leave. It can be up to 24 weeks of leave potentially, because they do not run concurrently. They're not lumped together. The NICU leave is a completely separate allotment of up to 12 weeks. So if you are in Colorado and you're subject to family, you want to make sure that you're aware of this new entitlement. If an employee takes time because of a NICU situation, be aware of that. You want to make sure that your managers who maintain your records or keep track of employee leaves are aware of this new entitlement under family in Colorado. And you also want to prepare for longer employee leaves, because the possibility again exists that two different types of leave under family could be run consecutively rather than concurrently. So that's just something to be aware of. Connecticut, they're in the process of expanding their paid sick leave law. So previously, the law only covered service workers, and those individuals had to be non-exempt. So think of people working in specific industries. They're paid hourly. Those were considered service workers, and the law only applied to them. Well, the law has now been expanded to cover virtually all private employers with 25 or more employees. And now the coverage is expanding to private employers with 11 or more employees. So the number of employees has shrunk in terms of who a covered employee will now be. And as of next year, 2027, that number is going to go from 11 down to 1. So paid sick leave is expanding vastly in Connecticut to cover basically all workers. What I would recommend as a compliance tip right now is if you're a small employer, check your employee count to see if you're now covered, meaning are you below 25, but are you above 11? Then you want to take a look to see if you're now covered. And if so, you're going to have to start providing that benefit to employees. Back on the topic of paid family and medical leave, Delaware is another state, as we mentioned, that has a paid family and medical leave program for employees within the state. House Substitute 1 has expanded and amended some of the rules in Delaware. So basically that law in Delaware, again, for paid family leave, it's for parental leave, caregiver leave, medical leave. It provides up to 6 weeks of paid parental leave, 6 weeks of paid family caregiver leave, or 6 weeks of paid medical leave per year. A recent amendment to that law, however, to be aware of is that now Delaware paid leave is going to be the primary payer of benefits. So if your organization runs a short-term or long-term disability benefit for employees, a wage replacement benefit, the primary payer of benefits to an employee who's out in Delaware and they're under the paid family and medical leave law, it's going to be the state is going to be the primary payer, and the disability insurance policy is going to be secondary on that. Also, an employer now can't require use of accrued paid time off prior to the receipt of Delaware paid leave benefits. So if there's some sort of rule that a company might have saying that an employee first has to use up their paid time off before they can receive the paid family and medical leave insurance program benefits in Delaware, you can't have that rule anymore, basically, as of January 1st of this year. So a compliance tip in Delaware would be, number one, the program is available, and number two, be sure you're following those rules with leave, who's paying for the leave, and whether or not you can require someone to use their other leave, paid leave first. The state of Illinois is right up there with California. It's another extremely employee-friendly state. Not a year goes by that they don't continue to pass a number of laws that favor employees over employers, and that's just something to be aware of if you're doing business in Illinois. There's going to be those challenges of compliance that you want to be thinking about. So an example of that is there's a new law effective as of the 1st of this month, SB 0212, and it's an amendment to the Nursing Mothers in the Workplace Act. So now employers have to provide reasonable break time to an employee who needs to express breast milk each time the employee has the need for 1 year after the child's birth, but an employer must now compensate the employee during that break time at the employee's regular rate of pay. So in other words, an employer can't require that an employee use paid leave during that break time, and an employer also can't reduce the employee's compensation during the break time in any other manner. So if the break goes into a period where maybe they would have punched out before, it's longer than 20 minutes, they're not going to be able to be required to punch out now. This is going to be paid time in Illinois going forward. As an employer, a compliance tip would be to update your timekeeping practices to make sure that if someone is taking a longer break for an activity covered under this law, that you're not reducing their hours or pay because they're doing that. Staying in Illinois, we've got an amendment to the Victims Economic Safety and Security Act, or VESA. If you're already doing business in Illinois, you're probably familiar with VESA already. It provides eligible employees with job protected time off. Sometimes it's paid, sometimes it's not paid, depending, to deal with issues related to domestic violence, stalking for themselves or a family member. If it involves medical care, legal help, counseling, things like that. VESA is to help people in a situation related to domestic violence or other issues. So now the VESA law has been amended. Employers are prohibited from taking an adverse action against an employee if they're using an employer issued device like a cell phone to record incidents that would be covered under VESA leave. So something like domestic violence, sexual violence, gender violence, or any other crime of violence committed against the employee or a family member or household member of the employee. So if you've got somebody, they have a company issued cell phone, you can't have a policy saying they can't record incidents that are covered under this law with the company phone. You can't prohibit that. You also, as an employer, can't prohibit employees from using that same phone that we're talking about in our hypothetical to access the data from the phone. You can't, even if you allow them, say they've videoed an incident that they say there's domestic violence, you can't then say, well, that file is our property, you don't have access to that. They do, under this law, now have access, even though it's your phone and your file. They can get that information from an employer legally to have evidence of something that happened that's covered under VESA. Compliance tips with this would be just make sure you're aware of this requirement. If you're issuing phones to employees and an employee has used the phone for something covered under VESA to record an incident, you've got to give them access to that data. And if you've got a written VESA policy, you might want to look at having it updated to address this contingency. Illinois has also made an amendment to their Human Rights Act, the myHRA. Employers are going to be familiar with this. What this means now is that it's a limitation on an employer's use of artificial intelligence or AI in employment. An employer under this law can't use an AI system where zip codes are a substitute for what the state would consider to be discrimination. So what that means is an employer can't favor or exclude zip codes because they think the zip code is either good, quote unquote. So, oh, we only hire people from these certain zip codes in the area. Or if the zip codes are considered bad, meaning we don't hire anybody from this area because those are terrible neighborhoods. If you're using an AI system, you cannot have that criteria in the AI to look at zip codes in that manner. In addition, an employer must provide notice of AI use in employment if the company is using AI to make employment-related decisions relating to recruitment, hiring, discharge, discipline, or other terms and conditions of employment. So think of, if you're using any of these systems and AI is in them, you'd have to provide notice if you're using computer-based assessment skills, personality quizzes, resume screening and ranking by AI, AI evaluation of facial expression, voice, or text during an interview, certain targeted AI types of advertising, and things along those lines. If you're using AI in any of those manners with hiring, you would have to provide notice to the applicants. You would not, however, need to provide notice of AI use for things like drafting a marketing content or internal report. Something like if there's an AI system included in a standard word processing document, for example, and those tools are not inferring, generating, or influencing employment decisions, you don't need to put a notice out for that. So if you've got Microsoft Word, you're using Copilot, Copilot is not getting into or connected with your hiring system, you wouldn't need to provide the notice at that time. So if you are using AI, for current employees, the notice must be provided annually after you have adopted or made substantial updates to your AI system. And if you're looking at applicants, it has to be part of the job notice or posting. Providing notice to people is done in various ways. It can be done in like a employee manual or policy. It can be posted either on the physical location. It can be sent through like an intranet for the company, and it should be included with any job notice or posting. So the compliance tip here would be, if you're using an AI tool in your employment practices in Illinois, be aware of these new requirements. This is sort of interesting. So Illinois has gone ahead and amended the Unemployment Insurance Act. They have basically done three things with this new law change in HB 3200. The first thing that they've done is they've expanded eligibility for uninsurance benefits to include individuals who leave work voluntarily due to a mental health disability. That's the first thing they've done. The second thing they've done, they've expanded how the state can recover benefits that are paid out to somebody who's later determined to be ineligible. That may not be as big of an issue with the employer, though it could affect your rating. And then there's also a rule in there that an employer can be barred from operating in the state completely if you're not providing certain information to the UI department in Illinois. You've got to pay your contributions in, and you've got to send in your new hire reports, and you've got to file wage reports with the state. If you fail to do those things, the state could turn around and completely bar your business from operating. Those are some pretty significant changes to be aware of. One of the things that we think about as a compliance tip is that if you're looking at your your UI reports from your insurer and looking at things, just be aware now that an employee could leave work voluntarily, potentially with a mental health situation, and still be eligible for UI benefits. Keep that in mind, and then also be sure you file your new hire reports and your wage reports, because failing to do so could get your business locked out from operating. Oh, let's go back one, Dan. We're going to talk about Indiana real quick. More of an employer-friendly state. This notice is just more of an FYI. The state now has passed a law where employees can access earned wage services, EWA. That means that if they've earned money, they can get it ahead of the payday using a different service. If you're interested in doing that in Indiana, there are a number of rules as an employer that you need to comply with if you're working with an EWA vendor. That's just sort of an FYI on that one. Another huge employment law change that has taken place and is effective now in 2026 is in the state of Minnesota. Paid family and medical leave is now in effect, called paid leave by the state. Minnesota is now one of the most employee-friendly states with some of these laws they've been passing. In fact, we did an entire webinar on this back in October that you can go back and check out if you do business in Minnesota. This law covers most employers, including small businesses, and many employees are going to be eligible for this law. It's administered by the Minnesota Department of Employment and Economic Development, or DEED. That's the same agency that administers the unemployment insurance system in Minnesota. Basically, the paid leave and the UI system are side by side now, and the employees apply to DEED if they want to take paid leave. So it's a similar process where an employee, if they lose their job, they apply to DEED for unemployment insurance. Now they also apply to DEED for paid leave. The reasons for leave include care leave, medical leave, things that are similar to existing leave laws out there. This new law, however, has got a couple pretty strong pieces to it. Number one, it provides job protection. Somebody can't be fired because they took paid leave. And number two, it provides wage replacement. We're not going to get into all the details on that, but that's a significant piece of it. Employees pay for a portion of the wage replacement, employers pay for a portion. Importantly, employees could begin taking leave as of January 1st, so the first of this month in 2026. So some compliance tips with paid leave in Minnesota. Your registration, your employee notices, and your employer account setup should all have been done by now. Going forward, as a compliance tip, you want to make sure that you're managing paid leave by making sure that there's job protection in there. You got to keep the employee's health insurance active, and you don't want to retaliate or interfere with an employee taking an approved paid leave time off. Also remember that paid leave can be taken concurrently with other leaves. This is an important detail to note. For example, if you're an employer with 50 or more employees, you could have written into your paid leave policy that it's going to run concurrently with other leave laws. For example, if somebody's on FMLA at the federal level, you could have a provision stating that the paid leave for Minnesota has to run concurrently. That way you're going to prevent leave stacking. That's something we're going to discuss in a little bit as well, but running those leaves or running paid leave concurrently with other applicable leaves is a way to help manage the amount of time off that somebody could take in Minnesota. Another big change that has happened in Minnesota that became effective on the 1st of this month are changes to the meal period and rest break law. Now, or I should say previously, employers had to provide adequate time for rest breaks, restroom time, and meal periods. Under the new law, rest breaks for non-exempt employees have to be provided. One 15-minute paid rest break for every consecutive 4 hours worked, and then an employee must be allowed to take one 30-minute meal break for any employee working 6 or more consecutive hours, and that meal period could be paid or unpaid. So now this new law, or these new laws, basically are codifying these time frames and when people need to take them. But the really important thing about this law change that we're discussing here is that there are penalties that are built into this law. So the updates to the meal period and rest break laws now have added teeth that can be used by the state or by an employee to come back at an employer. So if an employer fails to provide an employee a required meal period or rest break, the employer can be found liable for the wages the employee would have earned during the missed break at the regular rate of pay, plus an equal amount as liquidated damages. So in other words, an employee could recover double the value of their missed meal period or rest break. That's something that could add up quickly if you've got a lot of employees, excuse me. An employee could come after an employer directly, or they could get the state on an employer if they feel the state has not allowed them to take their meal periods or rest breaks. So this is an important thing to consider now, because this is an extra burden on employers. If, say, you've got an employee who is allowed to take the break, but they elect not to take it, the best practice would be if you've got a written waiver from that employee stating, yeah, the employer had allowed me to take the time, but I chose to not take that time. That provides evidence to you as an employer that could be used in your defense if an employee tried to make a wage claim for missed rest breaks or meal periods. Again, this law became effective on the 1st of this month. The compliance tips under this rule would be, make sure you're allowing your employees who are covered, mainly the non-exempt employees, to use these meal period and rest break times, and also obtain and keep written waivers if an employee chooses not to take a rest break or meal period. So New Hampshire, speaking of family and medical leave, New Hampshire has kind of expanded their program a little bit. New Hampshire employers with 20 or more employees are now required to provide employees with up to 25 hours of leave from work related to medical appointments for childbirth or a child's pediatric medical appointments. Importantly, this time currently is unpaid. You're not required in New Hampshire to pay for this time off, so it's different than a lot of the other states, but an employee must be allowed to use any accrued vacation or other paid leave they might have available if they're going to be absent for a covered reason under this law. Also, this law, even with the unpaid component, provides job protection. If an employee has taken leave, they have to be restored into their job. What I would say for a compliance tip here is just be aware of this new leave entitlement and be prepared to track use by employees. Keeping with the theme of family and medical leave, New Jersey has gone ahead and expanded by law the coverage of their family and medical leave law. Effective this July, the employer coverage threshold is dropping from 30 employees down to 15. So if you're an employer in New Jersey and you have 15 or more employees, as of July, you're going to be covered under this law. In addition, the employee eligibility requirements are being lowered. Previously, an employee would have had to work for 12 months and at least 1,000 hours to get this leave. Now it's only 3 months of employment and only 250 hours worked. One kind of burdensome piece of this is that leave stacking is allowed under this law. So when we just discussed Minnesota paid family and medical leave, there are ways that employers can have language stating the policy runs concurrently with other policies, so the leave is not stacked, meaning consecutive back-to-back leave chunks. New Jersey, leave stacking is allowed because the employee chooses which different type of leave they're going to use, and they choose which order they're going to use the time off in. So they might say, well, I'm going to take my paid sick leave first, and then I'm going to take my paid family leave. That's just an important thing to consider, that when you're managing this type of change in law that expands the employee use of leaves, you've got to be very aware from a record keeping standpoint, from a notice standpoint, all those pieces for an employer. You need to be aware now that the employee in New Jersey is basically in the driver's seat, and if they qualify for more than one type of leave, they probably could be run back to back rather than at the same time. So it's going to be important that in operating your business or in talking to your managers, they are aware of this change and are aware of this leave stacking possibility that's going to be going forward in New Jersey with their paid family leave. New York has enacted a new law called that relates to the State Secure Choices Savings Program. This requires creation of Roth IRAs for certain private sector employers. If you are going to be covered under this law, you have to meet this criteria. You've got to have been in business for at least 2 years. You got to have employed 10 or more employees in New York in the previous calendar year. And importantly, you're not offering another qualified retirement plan. So if you are already offering a qualified retirement plan, this law may not apply to you. But if you're operating in New York and you're not offering a qualified retirement plan to employees, you've got more than 10 employees and you've been in business for more than 2 years, you are likely going to fall under this program. The good news for employers, if you can say there's good news, is that there's no fees to participate in the program. There's also presently no employer contribution requirements. The requirement for the employer, if you're covered under this law, would be simply to set up the program. The employees who participate would have some fees attached to them, and you want to be aware of some kind of rolling compliance dates that are starting here in 2026. So if you're going to be covered under this law because you're not offering a plan to people, if you've got 30 or more employees, you've got to register by March 18th of this year. If you've got 15 to 29 employees, you've got to register by May 15th of this year. And if you're an employer with 10 to 14 employees, you must get registered in the program by July 15th. First thing, what I would say for a compliance tip is determine if you're covered by the law. Look at those criteria. How long have you been in business? How many employees do you have in New York in the last year? And are you offering a qualified retirement plan? If you are not offering a qualified retirement plan and those other conditions apply, you want to look at getting signed up for this. Again, right now, there's currently no fee for employers to participate. Another important thing that's happening in New York is that the use of consumer credit information in hiring is now being curtailed. You basically cannot use an applicant's consumer credit history. If you perform a background check, if you look at their credit history score, you basically cannot do that in New York any longer because it would be by law considered a discriminatory employment practice starting in April of this year. However, there are some exceptions. There are some carve-outs for when an employer in New York could still use a consumer credit report in a hiring decision. Those are if somebody is applying for a police officer job, for example. If somebody is applying for a job where they'd have to go through a state background check, you could still use the credit history. If somebody would require to be bonded in New York to do their job, then you can run a credit history. If the person is going to have a security clearance and they're working in New York State, you could run a credit check. If somebody has regular access to trade secrets, or they're working like in the national security sector for your business, you could still run a credit check. And if somebody is in a position, maybe they are in a financial institution where they have significant money responsibilities, maybe they're a controller at a group of small businesses, then you could run a credit check. But outside of those 6 exceptions, you're basically not going to be able to use a credit history in an employment decision. So a compliance tip with this would be make sure you adjust your candidate screening as needed. And remember that Yes, you can run a credit check on applicants, but it's in very limited circumstances. North Dakota has a new law in place where they are amending their employee tax withholding law. The state now prohibits employers from withholding or deducting income taxes from wages automatically. That's not something an employer can automatically do in North Dakota. Instead, they can only do that if they've got employee consent. So the compliance tip here would be to make sure that you've got employee consent before you start withholding income taxes from wages starting this month. That may seem like kind of a strange thing, but North Dakota has passed a law stating you just can't automatically withhold taxes from wages, income taxes that is. The employee has to provide consent first. The state of Oregon has made some changes in law that we want to discuss. They also have a family and medical leave insurance program. And one of the changes that they've made to that program is that now an employee is going to be limited by state law. They are not going to be able to receive family and medical leave insurance benefits if they are also eligible to receive either work comp or unemployment. So if you've got somebody that is out there using family and medical leave in Oregon, they can't concurrently receive work comp or unemployment at the same time. So if you've got workers in Oregon, just be aware of this limitation, that paid family leave is not going to be paid at the same time as work comp benefits or unemployment benefits. Also in Oregon, which as a side note, is an extremely employee-friendly state, they have now made a change to their unemployment insurance requirements. So Oregon law previously provided unemployment insurance benefits to unionized employees during a lockout only. And a lockout means that an employer prevents employees from working to force them to accept, employment terms initiated by management. A lockout is different from a strike, where a strike is where employees collectively refuse to work in order to pressure the employer to accept terms initiated by the workers. So previously, a unionized worker in Oregon was only eligible to receive unemployment if there was a lockout. In other words, when the employer was preventing them from working. Well, now the law has been changed so that people who are off work due to a lockout or a strike, and remember, a strike is an employee initiated time away from work. Now, strike is included for eligibility for unionized workers to get unemployment insurance in Oregon. However, those benefits are capped at 10 weeks total. Just a compliance tip to be aware of with this is if you have a unionized workforce, keep this expansion of unemployment insurance eligibility in mind. So again, before, if you lock them out, they could get unemployment insurance, but if they struck, they could not. Now, if they strike, they can get UI for up to 10 weeks. Really, this is a way it provides and empowers workers probably over the employers, because it gives almost an incentive to strike, because they know they're going to be able to get unemployment insurance for a strike when previously they would not. Oregon has also made an update to their paid sick time law. They've added a new reason for use, time off for blood donation. This is pretty straightforward, but one compliance tip to keep in mind with this is that the time off must be in connection with a voluntary program for the donation of blood that is approved or accredited by the American Association of Blood Banks or the American Red Cross. So in other words, the time off to donate has to be through a recognized organization. Maybe at your work location, a blood mobile comes once a year for people to give donations, something like that. An employee could use paid sick time, but if it's not a voluntary program that's accredited by one of the two organizations, then the time would not be eligible for use. Rhode Island has made a pretty significant change to their payment of wages law. Now employers are required to provide each employee with a written notice of specific conditions of employment when they're hired. So at the start of employment, a written notice has to be provided to the new hires as of January 1st of this year. The notice has to be in English and it has to contain specific information. It's got to talk about the rate of pay and the basis of pay, whether that's hour, day, week, shift, salary. It has to talk about allowances, if any, claimed relating to meals and lodging. It has to include the employer's policy on sick time, vacation, personal leave, and holidays. It has to describe whether the employee is exempt or non-exempt. The notice has to list deductions that may be made from an employee's pay. The list has to indicate the number of days in the pay period, what are regularly scheduled pay days, and when first wages will be earned. It's got to talk about the legal name of the employer and the operating name of the employer if they're different. It must provide the physical address of the employer's main office or principal place of business. And it's got to have a telephone number of the employer. So if you're working in Rhode Island, make sure you're aware of this notice requirement and you're providing the notice as of January 1st of this year. Rhode Island has also increased some benefits that employees might be eligible for. Those are the temporary disability insurance, TDI, and temporary caregiver insurance, TCI benefits. They provide wage replacements to Rhode Island-based employees who aren't able to work. So remember, the TDI is for the employee's own medical condition, and the TCI is to care for a family member or bond with a newborn. This program is being expanded now to allow for benefits and time off to care for a sibling. Previously, it was a spouse, parent, child, grandchild, people like that, but now sibling has been added into the mix. And a sibling under this expansion of the law is defined as a person with a common parent, which includes a biological sibling, a half sibling, a step sibling, a foster sibling, and an adopted sibling. This generally applies to employers with 50 or more employees, and it's going to be effective, or it is effective as of the 1st of this month. So just be aware of that. If you're covered under this law in Rhode Island, now you've got sibling coverage to be aware of and deal with. And our last state that we're going to discuss is Washington. Again, back to the topic of paid family and medical leave. As we mentioned earlier, this is a growing trend across the countries for certain states to provide this benefit. With the exception of maybe New Hampshire, as we discussed today, it's generally paid. It's a program to administer. It's something to be aware of for employers. And now Washington has expanded their program as well. So a couple things have happened with the new law change in Washington. Employees who now take leave under Washington paid family and medical leave it's being expanded, to cover employers with 25 or more employees instead of 50. That's going to expand over the next couple of years. So as of 2026, the number's dropping down to 25. In 2027, it'll be employers with 15 or more employees. And in 2028, it'll be employers with 8 or more employees. Another interesting addition to this law, however, is that the state legislature has said that leave stacking is more limited under this law. In other words, it's not like New Jersey where it's super permissive and leave stacking is basically built into the law. This is more like some of the other states where this leave is allowed to be run concurrently with other leaves, which prevents the stacking of back-to-back leave entitlements. However, in order to prevent leave stacking of the Washington paid family and medical leave, you've got to have notice in your policy regarding the requirement that leaves may be run concurrently, and the employees have to be made aware of that language in order to say, hey, you cannot stack your leave. There's a new notice form from the Department of Labor and Industry in Washington that has to be posted. I would recommend going to the LNI site and taking a look at that. Also, going forward with your Washington paid family and medical leave, You want to pay extra attention to your record keeping requirements, as they are always going to be tweaking this law, and you want to make sure that you're up to speed on providing it and any documentation that goes with it. Again, this is quite a bit of information. This is not every single new law in the employment law space in every single state, but we wanted to just highlight in the time we have some of the real significant ones that are happening this year. They are either in effect as of January 1st, or they're going to be coming into effect in the coming months in 2026. So again, an overview. How can we help you with this? This, it seems like a pretty big burden for employers in one state if it's a super employee friendly state, or if you're a multiple state employer, then your compliance obligations multiply from there. So some things that we can do to help you out. If you're a client of us, ask us. We're staying on top of these law changes. This is a very common area of questions for us. You can submit a question in the portal and get an answer from one of our attorneys. Subscribe to our weekly newsletter. We're going to provide updates on new laws every Tuesday. That's something that goes out Tuesday mornings, and you can take a look at it to see if there's something happening that's going to affect your state. The other thing that we can do is advise you on the best way to get up to speed and stay in compliance with these new laws. Again, we have a lot of experience in this area, and we're constantly monitoring law changes and how it's going to affect employers and our clients across the country.
Once again, thank you all for attending today. We really appreciate you joining us. We know that we moved through the material quite quick today, as Michael said, but if you have any questions on the new laws covered, we encourage our clients to open up a ticket directly in our Ask an Attorney portal. If you're not a client of ours and would like to learn more about our business and how we can help you, go to myHRcounsel.com and schedule a demo today. We hope to see you again in the webinar future, and be on the lookout for our follow-up email with more information. Thank you and have a great day.
Thanks, everyone.